Good day everyone. I will be explaining to you the Chapter 9, Jurisdiction and Procedures for Enforcement of Rights. Main points of discussion. Section 65, Primacy of Customary Laws and Practices. Section 66, Jurisdiction of the NCIP. Section 67, Appeals to the Court of Appeals. Section 68, Execution of Decisions, Awards, Orders. Section 69, Quasi-Judicial Powers of the NCIP. Section 70, No Restraining Order of Preliminary Injunction. Chapter 9, Jurisdiction and Procedures for Enforcement of Rights. The Chapter 9 talks about the rights of Indigenous people through its regional offices. All claims and dispute involving the rights of IPs. When we say jurisdiction, it is all about in law, in which the authority of a court is to listen and decide cases. A court may moreover have specialist functions inside a certain territory. In this chapter, there are 6 sections that we will discuss, and these are: first, we have Section 65, Primacy of Customary Laws and Practices. When disputes involve IPs, customary laws and practices shall be used to resolve the dispute. It is a set of customs, practice, and beliefs that are accepted as obligatory rules of conduct by indigenous people and local communities. Customary law forms an intrinsic part of their social and economic system and way of life, and its living form consists of binding rules followed in traditional communities and so on. Section 66, Jurisdiction of the NCIP. The NCIP, through its original workplace, might have jurisdiction over all claims and dispute including rights of IPPs. That no such debate might be brought to the NCIP unless the parties have depleted all cures given beneath their customary laws. The NCIP shall protect and promote the interests and well-being of the IPs with due regards to their beliefs, customs, traditions, and institutions. To formulate and implement policies, plans, programs, and projects for the economic, social, and cultural development of the IPs and to monitor the implementation. Section 67, Appeals to the Court of Appeals. Decisions of the NCIP shall be appealable to the Court of Appeals by way of a petition for review. Its original jurisdiction shall be taken by filing a notice of appeal with the court. It rendered the judgments or final order appealed from and serving a copy therefore upon the adverse party. An appeal is when someone who loses a case in a trial court asks a higher court is to determine whether or not the law was applied correctly in the trial court. Section 68, Execution of Decisions, Awards, Orders. Upon expiration of the period herein provided and no appeal is perfect by any of the contending parties, the hearing officer of the NCIP, on its own initiative or upon motion by the prevailing party, may upon his initiative or on motion of any interest party, issue a writ of execution. It becomes the final and executory requiring the sheriff, duly deputized officer to execute or enforce the respective final decision, order, or awards. Section 69, Quasi-Judicial Power of the NCIP. The NCIP shall have power and authority. Any arguments or cases that involve the NCIP should have rights and power to apply or interpret any appeal. The rules and regulations that governing the hearing and disposition of cases filed should be managed as those pertaining internal function would be necessary to see the purpose of this act. To manage the oath issues is right would require the attendance and testimony of witness or any documents that would be matter under investigation or hearing conduct in pursuing this act. Section 70, No Restraining Order or Preliminary Injunction. The indigenous people of the Philippines has its own law to follow as their cultural and ethics concern. Their rights and dignity must be protected with our Constitution to be preserved and developed through the year. No inferior shall have jurisdiction to issue any restraining order or writ of preliminary injunction against the NCIP. Thank you and God bless.